All rise. The Court of Appeal in the 5th District of the State of Florida is now in session. The Honorable Terry I. Sanders, Judge presiding. All persons having business before this court join here for the attention and you will be heard. The United States of the United States of America, the State of Florida, and this Honorable Court. Please be seated.
Okay, good morning, and welcome to a session of the 5th District Court of Appeal. I need to welcome, is that post 450 back there, the Explorer's post? All right, well, welcome. We have 4 oral arguments scheduled this morning. We'll take a break after the first 2, and that will give an opportunity for us to meet with any of the attorneys in the Lawyers Lounge, and members of Post 450 are invited to join the judges and attorneys there as well. That will be after the second case. Let me go ahead and introduce the other panel members. Seated to my right is Judge Palmer, and to my left is Judge Berger. There will be 15 minutes aside for the first case, and then 20 minutes aside each case thereafter. When the appellant comes up here, if you want to tell me how much time you want to reserve for rebuttal, I'll try to assist you in that regard. If anyone has any cell phones or other devices that can make noise, make sure you turn them off so that the attorneys are not interrupted in their presentation. All right, we'll take the first case of Clover versus State.
Good morning. My name is Joseph DeShiel. It's my privilege to represent the appellant in this case, LILLIAN Clover, who is a fellow professional colleague from the city of Titusville. I'd like to reserve 5 minutes for rebuttal. This case is an indirect contempt case stemming from a civil matter that was in Osceola County. It was a paternity case wherein Ms. Clover, my client, represented the respondent. The paternity action was brought, and it was determined from the early parts of the case that the child in question was born a meth baby. So one of the parts of the case for the respondent was to seek evidence of drug use by the petitioner. Ms. Clover moved to compel production of medical and prescription records. There was a battle over the initial stages of that, but ultimately on November the 26th of 2012, there was a hearing. There was no written order at that time, but there were minutes that the judge, of the judge's rulings where it says, excuse me.
Clover contest providing the calendar to the detective?
I believe the argument at JOA time was, and this was by Mr. Wolverton, the defense attorney, that the state didn't prove that the special prosecutor did not prove that it came from her. So that would be the argument that's before the court.
The detective testified to that, correct? That he got the calendar from
The way I recall it was he really couldn't remember all the details of how he got it.
Well, he couldn't remember exactly when he got it, whether it's personal delivery or mail, but he did say, didn't he testify that he did receive it from her?
That he had had contact with Ms. Clover, yes.
And that he would have received the calendar from her.
The trial court sort of looked at that as, and it was a big part of the hearing, as connecting the dots to establish identity in that case. But the initial ruling on November the 26th, 2012 was grant motion to compel, release medical pharmacy records, very important, sealed, not disclosed to respondent, then a disjointed phrase, since January 2011, not to be discussed without a court order if there is a need to file a motion. So this begs the question of, if it's not to be discussed, it's who's not supposed to discuss to whom.
Right, but that was
common sense.
Well, that's the whole point. It is common sense, and then when we get to the actual stipulated trial order, which is the basis of the contempt hearing, the trial judge seemed to sort of disregard the players in the case as to whether respondent in these pretrial rulings meant the respondent or the respondent's attorney.
what controls, the minutes or the court order?
The court order.
Okay.
Obviously.
And the court order says, respondent shall not copy, publish in any manner, disseminate, or share said records with any third party.
And our position at JOA and here is that...
That's the controlling language that we have to do.
Correct, but that respondent means the respondent and not respondent's attorney. And I would suggest to the court that...
Well, how
when
did your
it's-
client receive the documents? Because the sentence, either right before or right after, says, respondent shall be authorized to view petitioner's medical and prescription records for the purpose of preparing for trial.
There were orders in the civil case which required the disclosure. There were orders extending time for compliance. And those records had already been sent to Ms. Clover based upon the court's earlier minutes and the two orders extending time. So the way these orders, all these rulings should be referred to and interpreted is that the initial ruling was that Ms. Clover was to review them to prepare for trial.
Do you concede that if this order had said respondent or counsel for respondent shall not copy, publish in any manner, disseminate, or share said records with any third party, that the dissemination of the information on the calendar would violate that order?
No, I don't concede that because that is not a medical record.
Well, it says shall not copy, publish in any manner, disseminate, or share said records with any third party. And it looks to me, and it appears obvious to me, and to any reasonable person that would look at this calendar, that the calendar was created using medical records and information on medical records,
And that is,
and then disseminated to a third party.
but the question is whether the records or the information was the subject of the minutes and the order. Obviously, the stipulated trial order is what the basis of the contempt was. But there was a hearing after the conclusion of the civil trial where Judge Arnold made a distinction in discussing whether or not there would be a rule to show cause. He said to the special prosecutor, if these are not the sealed records, then it's probably not going to go anywhere. If they are the sealed records, then they have a problem. So he issued the contempt citation. I think there was problems with that, but I think he issued the contempt citation to find out exactly what was given to the officer. Now,
So would your position be that your client could read the record verbatim to somebody, as long as they didn't hand them the physical copy, that wouldn't be giving somebody a medical record?
our position is it wouldn't violate the court's order.
So that your client could read it verbatim to somebody, give all the information to them, and that would not violate this order?
Correct. Because it
What would be the
said,
purpose of this order if it could be that easily avoided simply by reading it to somebody as opposed to handing them a physical copy?
I think the fair reading of the civil case is that because this was typically acrimonious, the judge did not want the respondent, I don't know how to say his last name, I've tried several times, to get a hold of the actual records to post them on social media or otherwise harass the petitioner with it. Obviously, those records...
Okay, giving them to law enforcement officers so that they can file charges against her.
But again, the question is whether the order applied to respondent or respondent's attorney. And I think when we look at the charging document, if there's some ambiguity there, under the rule of lenity, the defendant is entitled to the interpretation in her favor. And obviously, one of the reasons why we're here is that I think this whole proceeding below took on the air of a civil contempt hearing and not a criminal contempt hearing, and that's why we have a lot of these procedural errors.
If we accept your narrow definition of respondent, not to include the respondent's attorney, then the previous order, which says the petitioner shall produce the records to respondent, would say that they couldn't go to your lawyer, they could only go to the party? Because they weren't allowed to go to the party, right? They were only allowed to go to the lawyer originally, right?
Right, I understand.
When the original order said they shall produce them to respondent, that obviously included the respondent's counsel, didn't it?
Well, no, actually, it meant, if you look at the whole November 28th minutes, it clearly implies that it's supposed to only go to the attorney, not the respondent. I think they just used respondent because it was the respondent's motion.
Okay.
Okay.
How could it be the respondent's motion if the attorney filed the motion? Wouldn't that be the attorney's motion? I mean, do you see the ridiculousness of the argument? I mean, it seems, when we're talking about respondent, you have to include the respondent's attorney. They are representing, they are acting on behalf of the respondent. They represent the respondent. I fail to see how we are to nuance an order to not include an attorney that's representing an individual because the order says respondent.
But then the June 4th order doesn't make any sense, because the June 4th order says, respondent shall be authorized to view petition of America. Ms. Clover had already gotten them, according to all the earlier orders, and she was not supposed to share them with her client. So when you say that it's obvious that it meant both the respondent and the attorney, I say two things. One, then the June 4th order doesn't make any sense. And two, again, this is a charging document. It has to be specific.
Well, let me ask you this. Would you agree that the attorney is the agent for the client?
Agent, you know,
I mean,
not much, the representative, I would say.
all right. Well, in the case of a corporation that's ordered not to do something, if the order says the corporation shall not do something, there's case law that says officers of the corporation, although they're not named, can be found in contempt if they're aware of the order, because officers are agents of the corporation. So I'm trying to figure out how that's different than a situation where an attorney is acting as an agent for a client.
Well, and that brings up the case I cited, Bank of New York versus Moorings at Edgewater Condo Association, where the underlying order said the financial institution and the attorneys had an obligation to do something.
Right, but even without that language, though, the law is that the officers who are aware of it can be held in contempt.
Well, I understand the law that you're trying to say. The judge at the contempt hearing said she couldn't find any law at all to say, in the context of
It's an
this
analogous situation. Corporate officer as agent of the corporation, attorney as agent for a client. I'm trying to see the difference.
Well, I'm trying to explain that you have to look at the progression of the discovery in the case to understand that the June 4th order, respondent can only mean the party. Otherwise, it makes no sense, because Ms. Clover already had the records. Two more comments, and then I'll reserve the balance. One, again, when it says records in the June 4th order, and then the later comment by Judge Arnold about the sealed records, going back to the November order, that would have to be the documents that came straight from the healthcare provider. And we've cited the statute on the confidentiality of healthcare records, that it's records that are kept, maintained by the healthcare provider. Clearly, what was submitted at the trial is not those records. So,
Well, what does publish in any manner mean? Publish can be written or verbal. In any manner makes it clear that it can be written or verbal. So what does, it seems like your interpretation is deleting the words publish in any manner, it's deleting the word disseminate.
well, what I'm trying to get the court to focus in is what is the records. And the records are the documents from the healthcare provider. And I think, again, if we're talking about some vagarity, under the rule of lenity, the interpretation has to be in favor of my client. So obviously there are several JOA motions, there were several procedural arguments.
Can I go back to the hypothetical that Judge Palmer asked you with regard if she had just read the records out loud? You said to someone, you said that would not be a violation of this order, but why wouldn't reading verbatim a record be publishing in any manner. Suppose the person that's the recipient of hearing that can't read or can't see. Wouldn't that be the only way for that person to understand what's in the record?
Except it's still not, what was submitted at the hearing, the indirect criminal contempt hearing, was not a record. It was work product. Everybody called it a work product. Okay? So, again, the only other thing I would say is, if we had the two earlier hearings, the one in front of Judge Arnold and the one in front of Judge Tennis, transcribed and recorded, this might be an issue that could have been cleared up. If the judge had granted, the indirect criminal contempt judge had granted a motion for statement of particulars, these things might have been cleared up. Again, I think the case did not take on the appropriate tenor for a criminal case, and we would submit that the elements that needed to be proven weren't proven, specifically with regard to medical records being distributed and with regard to who the order applied to. I'll reserve final minute for rebuttal. Thank you.
All right, thank you.
May it please the court, counsel. Andrea Totten on behalf of the state. Your Honors, I feel that the issues that have been raised this morning have been addressed pretty thoroughly in the trial court's order finding contempt, as well as the state's answer brief in this case. Unless there's something in particular that Your Honors would like to inquire about, I'm going to rest on my brief.
All right, any questions? All right, thank you.
Thank you, Your Honor.
No rebuttal? Yeah, there's nothing to rebut, Mr. DeShiel.
Excuse me?
There's nothing to rebut. She relied on a brief, so there's no right to rebuttal here, so thank you.